Assalamualaikum and a very good morning to Dr. Hana and fellow friends. We are from Group 6 and we will be presenting the case of Seba Dinamik and KPMG. And the title of the article is Seba Dinamik sues KPMG for alleged negligence breaching duties, published by New Straits Times NSD in June 2021. Seba Dinamik Holdings Berhad has taken legal action against its external auditor KPMG, claiming for substantial damages for alleged negligence and breaching contractual and statutory duties. So next, previous slide, Anis. Previous slide. Okay, so these are what we are going to discuss in the slide. We will start by discussing the relevant law involved, the law that being breached, and why KPMG was charged. Next, we are going to discuss about the sanction given, what KPMG should do to prevent the charges, and what a young auditor could learn from this case. Next. So we are going to start by understanding the facts of this case. So what happened in this case was, Seba Dinamik is a company that is involved in the business of oil and gas. In June 2021, there were audit findings raised by the auditor, which was KPMG, that stated the company was involved in questionable transactions between the companies and the suppliers. The suppliers, however, do not have office addresses, and when the auditor checked the invoice, there was no company registration name in it. That is why KPMG released the audit findings to us for an answer from Seba Dinamik. If we make normal assumptions, we expect that Seba Dinamik will answer the question and try to help settle the case properly. But what happened was, Seba Dinamik actually sued KPMG. Seba Dinamik said KPMG red flagging has tarnished its corporate image. It has portrayed that there are a lot of inappropriate things happening in Seba Dinamik, and as a result, the company's market capitalization has lost over 3.5 billion ringgit. Next, I'm going to pass to Anis to explain about the relevant law involved in this case.
Thank you, Kira. Next, I will present the relevant law involved in this issue. So from the issue, we have found three relevant law, which are first, professional negligence. This is when a professional, such as a doctor, lawyer, accountant, or auditor fails to fulfill the professional duties or obligations followed by the standard of their profession, which resulting in the client to suffer loss and damages. And this law also fall under the breach of duty of care to their client. Next, the second law involved is breach of contract. According to the Section 40 of Contract Act 1950, when a person and a party fail or refuse to perform according to the terms of the agreement. And the last relevant law is breach of statutory duty. The breach of statutory duty is the act of not perform at all or in accordance with the statute. The breach of duty is owed to the client and it also causes damages to the client. Next, I will pass to the next presenter.
Okay, now I'm going to talk about the law that being breached by KPMG. First, breach of contract according to Section 40 of the Contracts Act 1950, which the auditor failed or refused to perform according to the terms of agreement. KPMG was unable to complete the audit and subsequently resigned without completing the task due to the action brought against it. Second, professional negligence. Under the law of art, the duty of care of a professional may arise in the contract, such as consultancy agreement with the client, in part or by reason of a statute, and may be owed to a third party. Third is breach of statutory duty. Under Section 137 to 147 of the News Companies Act, it states that the method of appointing the auditor, the eligibility of a statutory auditor, and the duties and responsibilities of the auditor. Next. So we are going to look at why KPMG was charged. First, KPMG had concluded that several individuals who had signed audit confirmation requests on behalf of their companies did not exist merely based on calling the front desk receptionist of these companies to verify the identity. Second, When verifying a phone number of a vendor for Server Dynamic Holdings Berhad, KPMG had placed reliance on an open source phone book app called Truecaller, which produced an inaccurate result towards the ownership of the number. Upon being informed of this, Server Dynamic Holding Berhad obtained an official telephone bill registered in the name of SDHB's vendor to address this concern. Yet no action to verify the same was undertaken by KPMG for reasons best known to them. Third, next slide. The last reason why KPMG was charged is because in another instance involving a Middle Eastern foreign vendor, KPMG had performed a site visit to verify the existence of the office and concluded that the office did not exist. As the HB immediately informed KPMG that the reason they did not find the office was because the address concerned had a mix of numerical digits and Arabic letters, which the auditor misread and ultimately went to the wrong address. Proof of the correct address and office was provided by SDHB, but KPMG had refused to verify the same. That's all from me. I'm going to pass to the next presenter.
Okay, I will continue with the sanction given. Okay, so Server Dynamic has to file a civil claim for substantial damages against KPMG due to significant drop in their share price and overall market capitalization, which the share price fell about 60% and lost RM 3.7 billion in market capitalization. So, but there's no further action taken by Server Dynamic to KPMG, but because of that, KPMG has resigned as external auditor for Server Dynamic. And then after that, Server Dynamic has assigned new auditor, but then there's another problem arises, and eventually Server Dynamic and the officers acquitted by the session courts of the settling compounds amounting to 16 million ringgit. As Server Dynamic has to pay compound has to pay compound amounted to 3 million ringgit. CEO Abdul Karim Abdullah also compounded by 3 million ringgit, along with Executive Director Syed Nazim Syed Faisal, Group Chief Financial Officer Azhan Nazmi, and another one, Vice President of Accounts and Finance Office Osman, amounted 4 million ringgit compound, which he found falsifying accounting records of the company's subsidiary. So I'll pass to the next presenter.
So the next part is what KPMG should do to prevent the charges. So there are three suggestions. First is to seek for legal advice from an expert regarding the issue to help on better understanding on how to manage the issue and to find a solution. Second is to organize a meeting with the shareholders and discuss about the issue. First and foremost, the shareholders have right to know about the issue occurred in the company, and organizing a meeting can be an effective measure to prevent charges and potential lawsuit because they might come up with a suggestion for solution to handle the issue. And lastly, to prevent the charges, KPMG should firmly refute the allegations and contest any court proceeding to defend that they are not guilty for this case and demonstrate innocence and lack of liability. Next, I will pass to the next presenter.
So for the last part, I'll explain about what the auditors should learn from this case. Firstly, auditors should be independent, which is the auditor must be intellectual honest to be recognized as independent. He must be free from any obligation or interest in the client, its management, or even its owner. In the context of KPMG and Seba Dynamik, if KPMG engaged as the auditor of Seba Dynamik, they would be required to adhere to the principles of auditor independence. This would involve maintaining an arm's length relationship with the company and its management, avoiding any financial or personal interest that could compromise the objectivity and conducting the audit with professional skepticism and integrity. Secondly, auditors should practice 5 fundamental principles of ethics. The first one is integrity, which emphasize on act of straightforward and honesty. Objectivity, which young auditors should exercise personal judgment without bias. Auditors should have professional competence, confidentiality, and have professional behavior. The case emphasizes the importance of upholding professional integrity and ethical conduct in the face of potential conflicts or challenges. So, young auditors should understand the need to act ethically and in accordance with professional standards, even if it means challenging the client or making difficult decisions. Lastly, the auditor needs to ensure that they have two-way communication with their clients in any significant matters arising during the audit procedure. Any dispute or any problems shall be discussed first before anything happens. So young auditor should learn to communicate clearly and proactively with their clients, addressing any concerns or issues that may arise during the audit process. Timely and transparent communication can help auditor to prevent any misunderstandings and build trust for each other. So I think that is all from our group. Thank you.
Sorry, I forgot to unmute. Okay, thank you very much. Good presentation. I have a few questions, but before that, let me stop recording.